morning and welcome to PV Legal's daily newsletter. Today, we bring you a landmark ruling from the Supreme Court of India, one that every industrialist, tax practitioner, and policymaker needs to understand. The judgment is State of Maharashtra versus Reliance Industries Limited, delivered on the 25th of March 2026 by a bench of Justice P.S. Narasimha and Justice Alok Arade. The question before the court was deceptively simple, but its answer reshapes the law on fiscal exemptions. Can a state government, having once granted an exemption from a tax or duty, simply take it back? And if yes, on what terms? Here is the background. Since 1994, the Maharashtra government had granted exemption from electricity duty to industries running captive power plants, plants generating electricity for their own use. It was a deliberate policy to encourage industrial self-sufficiency and reduce pressure on the public grid. Industries like Reliance invested heavily on the faith of this concession. Then, in April 2000 and April 2001, the state issued notifications curtailing this exemption, citing budgetary constraints and the need for revenue augmentation. Captive power producers challenged these notifications before the Bombay High Court, which struck them down as arbitrary and discriminatory. The state came to the Supreme Court. The Supreme Court reversed the High Court. The court held firmly and unambiguously that a fiscal exemption is a concession, not a right. Captive power generators had no legally enforceable right to demand that it continue indefinitely. The right to enjoy an exemption is, in law, a defeasible right, one that can be taken away by the very same power that created it. Promissory estoppel and legitimate expectation, the court held, do not override a genuine exercise of fiscal authority in public interest. Revenue augmentation to address budgetary constraints is a legitimate justification. But here is where the Supreme Court introduced a vital constitutional discipline, and this is the most important takeaway. While the power to withdraw is valid, the manner of withdrawal must be fair. Industries that have structured their operations around a state concession cannot be subjected to abrupt reversals overnight. The court ruled that both notifications would take effect only after the expiry of 1 year from their respective dates. In effect, 1 year's notice is now the constitutional minimum before a fiscal exemption withdrawal can bite. This is a judgment of profound significance for the future of industrial policy and tax concessions across India. The message is clear. The state can take back what it gave, but it must give industry time to breathe. I am your host, and this has been PV Legal's daily newsletter. Stay informed. Stay ahead.